Majesty's Revenue and Customs.
Lady Simler will hand down the judgment.
Section 1219 of the Corporation Tax Act 2009 enables a company with investment business to deduct the expenses of management of that business in calculating its profits for the purposes of calculating its liability to corporation tax. However, by subsection 3A of that provision, expenses of management cannot be so deducted if the expenses are capital expenses. The question in the appeal is whether certain expenditure incurred by the appellant in circumstances I shall summarise shortly, now accepted as having been expenses of management, are capital or revenue expenditure. The appellant, Centrica Overseas Holdings Ltd, or COL, is an investment holding company in the Centrica PLC group. Its principal activity is holding capital investments for the purposes of long-term investment, from which it derives value, and its business is to manage its capital assets, not to trade with them. In July 2005, COL acquired a Dutch company with 4 subsidiaries. I'll refer to that as Oxxio. This investment in Oxxio was unsuccessful and generated significant losses. In mid-2009, Centrica PLC resolved to sell Oxxio and took immediate steps to achieve that aim, including instructing numerous professional advisors. In March 2011, following a lengthy process, the assets of 2 of the Oxxio subsidiaries and the shares in a third were sold by COL. The 4th Oxxio subsidiary was retained. The professional advisors retained in connection with the sale of Oxxio between July 2009 and March 2011 were Deutsche Bank, PwC and a firm of Dutch lawyers called De Brauw. COL paid them professional fees of a little over £2.5 million. This was the disputed expenditure in the case. COL did not seek to distinguish between different fees paid to different advisors. It claimed relief on an all-or-nothing basis for the disputed expenditure in its tax return for the accounting period ending 31 December 2011. HMRC denied the claim as not deductible because it was not an expense of management and maintained that even if it was an expense of management, it was capital in nature, so not deductible. COL appealed to the first-tier tribunal, which found that most but not all of the disputed expenditure was expenses of management, but dismissed the appeal on a basis that no longer concerns us, but was that the disputed expenditure was not incurred by COL itself. The upper tribunal allowed COL's appeal, holding that all of the disputed expenditure was both expenses of management incurred by COL and revenue expenditure, therefore deductible. On HMRC's appeal, the Court of Appeal agreed with the upper tribunal that the disputed expenditure was expenses of management, but held that it was capital in nature and therefore not deductible. On this appeal, HMRC has not challenged the holding that the disputed expenditure is an expense of management. COL, however, appeals to the Supreme Court on the question whether the disputed expenditure was capital in nature. For the reasons explained more fully in the judgment, the Supreme Court unanimously dismisses COL's appeal and holds that the disputed expenditure was capital in nature and therefore not deductible under Section 1219(3)(a) of the Corporation Tax Act 2009. I give the only judgment with which the other justices agree. Section 1219, subsection 3A of the Corporation Tax Act, which provides that expenses of management of a capital nature may not be deducted, is on the face of it in similar terms and achieves a similar position for ordinary trading companies as Section 53, subsection 1 of the same Act. Notwithstanding that, COL argues that as a matter of statutory interpretation, the words expenses of a capital nature in Section 1219(3)(a) have a more limited meaning than the similar words items of a capital nature in Section 53(1) and were intended only to exclude the acquisition costs of investments themselves, together with expenditure not separable from those costs and a limited category of fixed capital costs, such as buildings. The Supreme Court rejects that contention. The words of section 1219(3)(a) are clear, they are straightforward, as is their statutory context. Expenses of a capital nature in that subsection and items of a capital nature in the similar section 53(1) must mean the same thing. Both were intended to carve out capital expenses by reference to the concept of expenditure of a capital nature that was already well established in the tax code, and by reference to authoritative case law when the carve-out for expenses of management was first introduced. Parliament can therefore be taken to have been aware of the established capital revenue case law when it first legislated to introduce the capital bar in what was Section 38 of the Finance Act 2004. It would be surprising if the exclusion for capital expenditure was intended to have a special or a different meaning without anything to signal that this was so. The supporting material, the legislative history, and the timing of the introduction of the capital exclusion all demonstrate a clear intention to align the trading company and investment company rules in relation to excluding capital expenditure in this context. That same legislative intention is also readily inferred from the fact that the capital exclusion was reenacted in section 1219(3)(a) of the 2009 Act, using the same words, of a capital nature, as those found in section 53(1) of the same Act, again without any limit or qualification signalling a contrary intention. Accordingly, section 1219(3)(a) is to be interpreted in accordance with well-established capital revenue principles. The question whether expenditure is capital revenue is a question of law. The previously decided cases reflect the fact that items of expenditure on the borderline can be difficult to assign between these two broad categories. There is no single test that can be applied to decide which items are capital and which are revenue in every case. Much depends on the particular factual circumstances. Nonetheless, the capital revenue case law is useful in providing illustrations of the approach adopted and of the factors regarded as relevant in a particular set of circumstances. The principles derived from the cases are useful, provided that it is recognised that they cannot automatically be applied to a different fact pattern or circumstance. I describe some of those principles in the judgment. It is sufficient for present purposes, however, simply to say that whereas the investments of an investment dealing company are revenue assets or circulating capital with which it trades, the investments of a holding company are capital assets or fixed capital, and its business is to manage those assets. Thus, Coal's investments are capital assets, and this includes its investments in Oxxio. Where a capital asset is bought or sold, it can generally be assumed that money spent on the acquisition or disposal of that asset should be regarded as capital expenditure. While fees for professional and advisory services are capable of being either revenue or capital in nature, such fees usually take their character from the commercial or business transaction for which they are incurred. Here, on the first-tier tribunal's findings of fact, Oxxio was an onerous capital asset. The transaction achieved in substance the disposal of this loss-making investment from the Centrica Group. Looked at objectively, once a commercial decision was taken to dispose of the Oxxio business, the services of Deutsche Bank, PwC and De Brauw were obtained to enable management to achieve that disposal. The disputed expenditure was both directed at and focused on bringing about the disposal, in whatever form that transaction ultimately took. It was money expended to achieve the disposal of a capital asset and is properly regarded as being of a capital nature. It was not therefore deductible as an expense of management for corporation tax purposes, and the appeal accordingly is dismissed.
Thank you. The court is now adjourned.